So I'm delighted today to be joined by our resident expert, Rachel Rigg, from our Manchester office. So much to my relief, and I imagine most of our team, it's lovely to have an expert in our ranks on all things data subject access requests. So I'm sure most of you have come across them. Obviously, they're time consuming. They require a lot of resource. They often used tactically. So Rachel's going to give us some helpful information about how we handle them. So on that basis, I'll hand over to Rachel.
Thanks, Laura. I mean, I don't know how anyone doesn't love DSARs because I think they're brilliant. But as Laura said, Laura's our partner in our Leeds office, and I'm senior associate working in Manchester. Anything DSAR related is my bag, but I am an employment lawyer by practice. And so contentious subject access requests is more something that I have developed a little side hustle in. I'm sure those of you who have joined today because you're working in HR will probably know most people who bring subject access requests are employees, and it tends to be alongside some sort of tricky dispute or exit or negotiation. And it's a really good tool for employees to use as leverage because they are costly and difficult to respond to. So with that in mind, we know DSARs end up landing on people's desks that might never have had data protection training, or maybe you're a data protection worker where this is something that you deal with regularly, but you just need a bit of a refresher on some of those practical tips and tricks in your toolbox that can make managing DSARs so much easier. So to start, we'll go dry. We'll talk about the fundamentals of data protection law. Now, I'm not intending to spend a lot of time here, but this is just a bit of a refresher, particularly if this isn't something anyone has looked at since the GDPR came in, coming up 10 years ago. Data protection law has always existed in modern times, but was reformed in 2018 with the introduction of GDPR and the Data Protection Act 2018. Now, these formalised some things that already existed and some of them didn't, but these are your data subject rights. So as an individual, you have the rights about your data that you understand how it's used, to access it and see what somebody has about you, to rectify data that's wrong, to erase data that people don't need to hold on to restrict processing of your data, for data portability, which is lifting your information out and being able to take it somewhere else, to object to the processing of data if there's not a basis to do so. And also something that we're seeing a bit more of now, how automated decision making is carried out on your personal information. And then in about 2 days' time, the right to complain about how your data is processed, or data protection generally, is coming into force. So that's just the picture. So the access of data, the right of access to your information, is something that has been around for a while, but that's what we're going to talk about today. Now, our lovely diagram here talks about data protection principles, which I won't go into a huge amount of detail on. But these are the sorts of things when the law was created and when the regulators are enforcing data protection law that they're looking for. And the most important ones that I think most people will be aware of will be about transparency. And that's where this right of access comes in, is that you are being transparent about what information you process about people in your systems. Now, you're probably thinking, employees know what data we process and they give it to us. They give us their name and we create them an email address. The law was designed for, companies that might rake data from the internet and need to tell people where they got it from and why they have it. And so it's really sort of misused in this employee context. So contentious subject access requests, my favourite. I could deal with them all day. And this is the right for individuals to obtain a copy of their personal data, as well as other supplementary information, which is one of the things that most people don't actually know about. Now, that means that when someone makes a subject access request, we have 1 month, which I call mirror dates. So, if someone making a request on the 1st of June is entitled to their response by the 1st of July. But what does personal data really mean? Personal data is anything relating to, so it needs to be about someone, and that person needs to be an identified or identifiable living natural person. And identifiable also means if data is compiled with other information, would we be able to work out who that is? So for anyone who has ever thought, it's great, we're going to give this really problematic employee a code name, that would be bang to right still their personal data, because it relates to an identifiable living natural person. So some of the common questions we get: what does a subject access request normally look like? It can come in any form. It can be made to anyone in the business. And so you really need to make sure that employees understand how to recognize a subject access request when it's made. If a request is made, we also need to make sure that any information that's due to be deleted isn't deleted. So if there's any potential that something that could respond to a request would be, subject to deletion because of retention periods coming around, or maybe someone who holds a lot of that information is leaving the business, we need to take steps to preserve that data at that time. Access to copies of personal data does not mean just giving copies of emails and redacting things out. That is a really legitimate way of doing it, but you can also provide copies of personal data by lifting out information and presenting it in a table, as long as you give enough context so that someone can understand, if it's in a table, what the header of that column was, etc. And that can be a really effective way of making it more cost effective, time effective to carry out, but also making it so that you're not handing over a lot more information than this individual is entitled to. Now, really interestingly, the ICO guidance gets more and more employer friendly every time I look at it. And one of the things they've written is the fact that somebody just receives an email does not make the email about them. So a really easy way to use this personal data aspect is to say, thanks, employee. You already have access to all the emails you have on your system, so we're not going to give you those because you can look at them now. And secondly, in terms of emails you've sent or received where you've not been mentioned within them, we've got 2,000 emails that just have your name, your email address, and your signature, your phone number, etc. in them. And we're not going to give you copies of them. Or we might give you one and say, here is an example. So that's a really easy way to deal with a lot of it. And that guidance is really helpful for employers. That entitlement for someone to receive their personal data does not mean that they have an entitlement to receive data about other people. And we'll talk about that in a bit more detail further on in this sort of presentation. In terms of, right, can I just send the employee privacy notice? You totally can. That definitely deals with that obligation to provide that other supplementary information, but you still need to give copies of personal data alongside it as well. So hopefully those are some starting tips and tricks that will help you manage those requests a bit more intentionally. And intentional obviously means less volume, less work. That's what we're aiming for. So we've received a DSAR, we recognise it as a DSAR. What do we do next? The first thing to consider is if we have to reply. So the guidance in the law says that if a request is manifestly unfounded or manifestly excessive, we don't need to reply at all. Now, manifestly unfounded is quite obvious and it's quite a high bar. So it's someone who is offering to withdraw a subject access request in exchange for money, or someone who is just harassing the business with no real purpose other than to cause disruption. And you might be thinking, that's every DSAR I've ever seen, Rachel. What are you on about? It's a really high bar. So for us to be able to say, no, we're definitely not going to comply with this request, the request itself has to state something to that effect, like, I am doing this just to create a headache for you. And that would be enough for us to say, no, we're not going to deal with it in that circumstance. It can also be if it's targeting a particular employee in a way that we think is harassing or is a personal grudge, or where someone systematically sends different requests as part of a campaign. And the kind of benchmark there is like once a week, not, 3 in the space of 6 months. In terms of manifestly excessive, it's where a request is clearly or obviously unreasonable based on whether it's proportionate when balanced with the burden or costs involved, which you might appreciate is incredibly vague and not very helpful. And so what we have in terms of guidance is factors we can think about whether we think it's excessive. And that can be the nature of the information that's been asked for, the context of the request, whether it's part of a grievance or something else. Is it clearly focused to that issue, or does it go much broader than that? How damaging would it be to the individual not to provide that information? And that's part of that balancing act between the two. So manifestly unfounded, manifestly excessive is a really high bar, but if we get there, we can refuse to comply with the request, or we can decide to charge a fee. Now, this is where the guidance gets quite helpful. Back in the day, pre-2018, you might remember that a DSAR would just cost a requester £10. Great, £10, that's going to compensate for all the hours involved. If the request is, we think, manifestly unfounded or manifestly excessive, we can charge an administrative fee based on our costs. So the time it would take for someone as an administrator to go through that at, a sensible hourly rate it would cost the business to do it is a sensible administrative fee, as well as things like data hosting costs or printing charges or similar. So if you're in the remit of manifestly unfounded or excessive and you are thinking about what to do, perhaps go down the route of, look, we'll proceed, but we're going to charge you for it. So let us know if you still want to go ahead on that basis. It's nice, it's helpful, and it shows us that we're really trying to see that through. So confirm ID. I know it might seem like a bit of an extra step when we have someone that we know is an employee of the business. But if they're using an email address we're not certain of, or someone else is making the request on their behalf, confirming ID is a really important step. The majority of data breaches happen because information is shared through subject access requests that shouldn't be. You can also stop the clock if you need to clarify the request. The bar on that seems to be higher. It used to be that you could only stop the clock if you really could not understand what the request was for without the assistance of the individual. But the ICO guidance is looking more understanding on that point. So very broad requests seem to fall into that remit. And we can also ask for an extension of time. And I say ask, we can inform an individual that we're relying on an extension of time. It's something we justify for ourselves. So that extension does allow us an extra 2 months on top of that 1 month deadline if the request is complex. Volume alone is not going to get you there. But these are all the things that you need to think about when it comes to your initial response, so that when you acknowledge that subject access request, you can set out, we think it's manifestly unfounded and this is why, or we're going to charge a fee, we need to stop the clock, or we're going to have the extension of time. And that must happen within the first month of having that subject access request on your stocks. So we've reviewed our DSAR, we've looked at what we're going to do in terms of stopping the clock, and we've got the information we need and we're ready to proceed with searches. This now has a statutory footing, which is for reasonable and proportionate searches. So when someone's made a broad request, you can explain to them to say, look, it's not going to result in you receiving every little piece of information about you in the business, because we've just got to make reasonable efforts to find this information. However, if there is something specific you're looking for, please let us know and we can make sure that's included. And that goes back to that transparency principle. So reasonable efforts to find and retrieve the requested information, but not something unreasonable or disproportionate to the importance of providing access. And where you have someone's name appearing throughout their employment, it's not going to be something that's proportionate in that setting, in terms of the shock of how their information has been used. It's like, yes, you wrote a lot of emails in your employment with us. What a surprise. So we've conducted our searches and we are left with our responsive data. And this is where your exemptions come in. So these are the requirements in the law that say, you know what, if this information is about crime, legal privilege, management information, etc., then you don't have to provide it to your data subject. So the key ways these work for employers, and really looking at it in this way: crime and taxation. If providing the information under a DSAR would impact an investigation of a crime, we don't have to disclose it. So let's say that there's been an accusation of theft on site by an employee, and we've got CCTV that's relevant. We've given it to the police, and the police are investigating. Now, if someone makes a subject access request, like the alleged perpetrator, we wouldn't have to provide them with that CCTV, because doing so could prejudice that investigation. But if that investigation was complete already, then there's no need for us to hold it back. So it does crop up in an employer setting more than you might think. Legal privilege still applies. So if you've been writing back and forth with a lawyer like us about what you need to do in a situation, then that can be withheld from a DSAR. Or if it's a document you've prepared internally without a lawyer, but it's in anticipation of litigation, then that can also be withheld. Management information. So, for example, the one that the ICO gives us is a redundancy situation that hasn't been concluded. If providing information to the data subject would prejudice a management planning activity or forecasting activity, then we can withhold it on that basis. So like a redundancy process where someone wants to understand how they've been ranked against other employees, but the decision hasn't been made yet or communicated in the business about the potential restructure, then they wouldn't be entitled to that information under a subject access request. Similarly, negotiations with the requester. So if you're in settlement negotiations with someone, they wouldn't be entitled to have a look behind the curtain and see how you're discussing those. And confidential references. So if you are thinking about, providing a reference to someone in a new role, or you've received one, that is exempt from disclosure under a DSAR. So these are just the most likely ones that work for employers, but there's all sorts that you can use here, and definitely different ways you can think about it to help. So, information about other people, and we know that employee DSARs tend to be inextricably linked with information about others, whether it's a management decision or a sort of HR having a conversation about a process or things like that. We know that people's information is inextricably linked in this context. Now, you do not need to provide information under a subject access request if doing so identifies someone else. And one of the key examples that the ICO has given us specifically is things like witness statements given in confidence. Now, a witness statement that would be given to an employee anyway, like in a disciplinary process, is probably something that is reasonable for us to disclose. But if it's something where they wouldn't receive it, like under a grievance, where someone's made employees come forward to talk about a really scary incidents of sexual harassment that they've experienced, and the harasser makes a request, it would be reasonable for us to not disclose that information to that individual in that circumstance. So it's a balancing act. It's about balancing the right of access versus the rights to protect other individuals' personal data. But we also have the benefit as employers, where we not only have an additional obligation in terms of our trust and confidence, our duty to our employees, that can help us lean more heavily on not disclosing information about people we're protecting versus that right of access and how important that is to that individual. So it's not a case of asking for consent from people. It's a case of carrying out that balancing action, how reasonable we think it is in the circumstances to disclose. I tend to fall on the side of, if this is something the individual knows about already, you can have it. No concerns about that at all. But if it's behind the scenes conversations about confidential things that people aren't expecting to be put in front of that individual, I'm more likely to withhold it. So we've acknowledged our request, we've done our reasonable searches, we've applied our exemptions, and we've redacted or withheld third-party data. And that's just the point where you wrap it all off by sending your copies of personal data, and we really strongly recommend password protecting it, because there's been so many instances of them going to the wrong person with a similar name, or a .com rather than a .co.uk email address, and ending up in the wrong hands. So password protect and provide the password through a separate format to make sure that there's no risk that it goes to someone it's not meant to and ends up being a data breach. And you provide it alongside that list of supplementary information, which should really be covered in your decent employee privacy notice if you have one already. But yeah, so that is our whistle-stop tour of sort of DSARs in a nutshell in our bite-sized session. I think we do have a few minutes for any Q&A if anyone's got particular questions. Or Laura, I know you love DSARs.
I do. I love it when you can cover them in 25 minutes. Well done. I mean, I thought that was really useful. I always do find these really useful. I think there's some really good practical tips there. I just made a couple of notes as we were going along, but particularly on the lines of just because somebody receives an email doesn't mean that that would have to be disclosed under the DSAR, because I think the obvious thing is just do a search of people's names and sort of share everything. So then that was really helpful. I think the exemptions were really interesting. Things like legal privilege, that feels obvious, that would be exempt, but the management information, I wasn't aware of that. Yeah. And of course, the little tip on password protection, because the last thing you want to do is comply with a DSAR and actually create a data breach. I just had a couple of questions. I'm conscious we've had a question actually, but I'll just ask mine first while I look at that. So you mentioned the training people on how to recognize a DSAR.
Yeah.
Does the email, for example, coming in from somebody have to specifically say, I am, making a request under...
Not even, yeah. So that's a really good point, Laura. So a lot of the time it can just be, ICO guidance is a bit woolly here because they love to support the right of access, right? But if an employee writes to you and says, well, actually, I really want these documents, then the ICO says you should really recognize that as a subject access request in itself. Which can make it really hard when you're working in HR. I know we've got a few on our desks of people sort of hopping up and down, demanding things before a process takes place or similar. So I would say it needs to be specific enough that you can see it through it to be a DSAR, but it does not have to say it. And it can even be over the phone.
Okay. Oh, interesting. So it doesn't need to mention subject access request, doesn't need to refer to the privacy notice.
No.
So some requests that you get even through grievance processes might qualify.
Yes, but that's when your exemptions kick in about forecasting, so that you're not providing an outcome of something that's live. And then privilege, if it's because we're anticipating litigation, or third-party information that you couldn't disclose that information to them. So there's other ways of treating it like a DSAR and getting to the same output, which is, there's very limited information we can provide you with.
And presumably if you do send it, so you can see a scenario where somebody just sends everything because they're not going to go through it and start trying to apply their mind to the exemptions. Presumably then you're essentially just waiving your right to rely on those exemptions.
Exactly.
Yeah. Okay. One final point, and it wasn't a question, it was a very nice compliment that we got in. So final question from me. You mentioned the right to complain. Very opportune, comes in 2 days' time. Yeah. Is there anything more on that? Again, can somebody just send an email essentially? Is there anywhere it has to be directed or anything they have to say?
Yeah, I mean, we're actually, Laura, this is such a good segue, and I know that you've not been paid to do this, but we're going to do a sofa session specifically, which is our little Horsfield Menzies video updates on the right to complain. But the cliff notes are, make sure that you have a way that people can understand what to do with a complaint if it comes in, and where it should go and who should be responsible for it. But there is no need for it to be made in a specific format. But someone who's making complaints about their data, how data is being processed generally, needs to have somewhere to go and someone to look after it, so a proper response can be given within 30 days.
Wow. Okay. Well, I didn't know that about the sofa session, but tune in for our next sofa session. Excellent. Well, I don't think we've got any more questions. As always, please do just follow up if anybody's got any questions. This is recorded. Hopefully it will all go through properly. And then if anybody wants a copy of the recording, would like to share it with their teams, of course, please do request. Thanks again for joining. Thank you, Rachel. And hopefully we'll see you on the next one.